The information related to adjudication as well as its outcome is private and confidential to the parties, even if one of the parties is a public entity. In order to share the information with third parties, the parties to the dispute need to first expressly agree that any disclosure can be made.
Adjudication is conducted on the documents rather than in person. This means there is no formal hearing or meeting during an adjudication proceeding. The evidence and submissions are given in writing. An adjudicator has the power to call a conference or to inspect the works. However, it is very rare for this to take place.
No, you're not required to have a lawyer act for you. However, if you have any questions or concerns about your legal rights and obligations, you should always seek independent legal advice.
When you choose to prepare and present your own claim or response, it may also be worth asking a lawyer who is experienced in construction law and adjudication process to review your submissions and evidence before you serve them on the adjudicator and every other party. That can be a cost-effective use of that resource where the amount in dispute is relatively modest. No, parties to construction contracts cannot contract out of the Act. Any party to a construction contract has a statutory entitlement to refer a dispute to adjudication at any time that a dispute arises under the contract and does not require any other party's agreement to refer to the dispute to adjudication or as to the selection of the adjudicator to be appointed. You can use the template documents on the Building Disputes Tribunal website to prepare and serve a notice of adjudication on the respondent and then, after waiting 1 working day, apply for the appointment of an adjudicator by completing this simple online application form. It is easy and as quick as that.
An adjudicator's determination is binding unless or until it's altered or set aside by a court, arbitral tribunal, or by agreement of the parties.
While adjudication does not necessarily achieve a final settlement of any dispute under a construction contract, because any of the parties has the right to have the same dispute heard afresh and determined in a court, or by any arbitral tribunal if the contract provides for arbitration, determination is binding in the interim, and the empirical evidence to date overwhelmingly indicates that the majority of adjudication determinations are accepted by the parties and complied with as the final result.
BDT provides a fixed-fee adjudication service for low-value claims of low complexity, our LVC service, and the general claim service for larger and/or more complex matters. LVC claims are claims for less than $100,000.
Ultimately, the adjudication fee payable will depend on which track your claim proceeds along, the LVC scheme or general claims. Regardless of which track you are in, you will still receive the same high-quality, fully administered adjudication process. You can use our online fee calculator or just get in touch and we can provide you with more information.